So I want to start with Meta and Facebook. Mark Zuckerberg coming out this week and saying, we're not going to censor anymore, essentially, right? I mean, he's got this cool guy vibe, and he says, we're not going to censor anymore. And not only that, but we're going to bring back political discourse. One of the things he had said a few months ago was, we're not going to censor anymore. He kind of went down that road. But then he said, but anything political, we're just going to basically shadow ban, which is like, well, that's censorship, Mark. But he came out then this week and said, you know what, never mind. We're going to give this a go. We're not going to censor. And what's interesting is that Children's Health Defense had lobbed a lawsuit against Meta only days before Mark Zuckerberg coming out with this announcement. Can you tell us about that lawsuit? What were you guys going after them for?
Absolutely. So we started this lawsuit, Kim, back in 2020, because even as of 2019, then Facebook was censoring us in a whole variety of ways. They were shadow banning us. They were putting Center for Disease Control information on our webpage without our consent, in essence, telling viewers the information that Children's Health Defense is putting out is false. You should go to the CDC for accurate information. Then they demonetized us. They took the donate button off of it. And then by 2022, they deplatformed us altogether, both on Instagram and on Facebook. And we've never been reinstated. So we filed a lawsuit in 2020 in the Northern District of California, as we have to do. And if you can believe this at this point, Kim, the federal trial court thought that our case was dismissed on the notion that it didn't present plausible evidence. Well, after that happened, we had the Missouri v. Biden case proceeding, where there was discovery in the Western District of Louisiana showing there were reams of emails going back and forth from the White House to Zuckerberg directly to all of his minions, saying, shut down Children's Health Defense, shut down Bobby Kennedy. We don't care. The White House saying, we don't care if the information's accurate. This is causing vaccine hesitancy in particular. And so the case then went to the Ninth Circuit Court of Appeals. Again, the Ninth Circuit affirmed the district court, and they somehow, the majority was able to rationalize to themselves, not looking at the 11 plus documents we had sent proving that not only was this plausible, it happened that Meta was working as an actor together with the White House to censor unfavored speech. However, there was a fantastic dissent in that Ninth Circuit decision saying, listen, this is the new public square. This absolutely appears to be censorship. We don't know. Certainly, the First Amendment is implicated here. And because Facebook, Meta, has liability protection through the Communications Decency Act that Congress passed in the 1990s, you have to look at this in a different way than you're looking at it. You have to understand that these people are being encouraged by the government and they have liability protection from the government. And you have to have other rules of the road that constrain this kind of overt censorship that obviously, at least potentially, violates the First Amendment. So now we're before the US Supreme Court. We think this issue is of importance to every American. We need to be able to have free expression in this new public square. And we're hopeful that the Supreme Court may take this case. We'll have to see.
Now that Mark Zuckerberg has come out saying, yeah, we're just not going to censor anybody anymore, wouldn't the court maybe come back and just say, well, this is a non-issue?
Well, I think that that's what Mark Zuckerberg is hoping for. That's my opinion, Kim. I think that this is gaslighting on an extraordinary level here. This guy has been censoring not only us, but probably you, all kinds of independent voices in politics, in health for the last 5 years. And now he's like, oh, yeah, I think maybe we went overboard and we should get back to first principles. The First Amendment cannot be decided at the whim of Mark Zuckerberg. And we really do need the U.S. Supreme Court to step in here and say, yeah, we really have to take a really deep, hard look at this. And we do have to have some rules of the road. There are rules of the road around broadcasting, around newspapers that don't exist in what was the Wild West for the last 30 years. That's got to be over so that we can't have this happen ever again, Kim, where the federal government tells the social media platforms, censor the disinformation dozen, of which Robert Kennedy was one.
Right.
And they also specifically mentioned Children's Health Defense.
Yeah, they did. Very much so. So what exactly are you seeking? What is when you're going in front of the Supreme Court, what are you asking the court to decide exactly, or what kind of what sort? I mean, you wouldn't be seeking an injunction, right? Because he's already,
No.
or would you be?
No, we're asking the court two questions, Kim. We're asking them, does this implicate the First Amendment when a liability protected social media entity does what it did? And secondarily, uh, are they responsible, and how are they responsible as being a joint actor together with the government? There's very important Supreme Court law about joint activity, and it relates to drug testing. It's a precedential case that related to railroads having liability protection for doing drug testing. And the court said, no, they're not absolutely liability free when they have been encouraged and they can't suffer any consequences. This may be an invasion of privacy. That was a Fourth Amendment case. But we think it's directly analogous to this situation where Facebook can't say, oh, yeah, well, we didn't do anything because it's our platform and we're a private company. Well, no, you weren't really a private company if you were working hand in glove and you were engaged in censorship by proxy.
Wouldn't that be a lawsuit more against the government? I'm just curious how, I mean, Meta, wouldn't they just say, well, look, the government made us do it. And what are we supposed to, if the government was breaking the law, the government was breaking the law and they shouldn't have
Right?
come to us and made us do this.
I love that question, Kim, because we also have a case against the government, right? So Kennedy v. Biden, which also includes Children's Health Defense as a plaintiff, we are right now before the Fifth Circuit Court of Appeals asking for an en banc hearing. So this is another long-running lawsuit where we want to hold the government actors directly accountable for having asked the social media platforms to censor us by proxy. That clearly, in our view, violates the First Amendment. And the district court Judge Doty in the Western District of Louisiana, saw it that way, that the case should continue. There should be discovery. We should find out exactly what happened because, again, we, under the First Amendment, the government cannot censor individuals. It cannot censor unfavorable political speech or health-related speech. There are certain
Yeah.
categories like dangers to individuals, fire, child pornography. There are areas that the government absolutely can censor, but political speech and health speech are not among them.
Yeah. So what was the outcome of, if you could, or is it still ongoing, the Missouri v. Biden case? That one,
It's
if I
it
remember
actually is
correctly,
ongoing.
it is
It is
still
ongoing.
ongoing,
Well,
but
I
the
tell you,
last
they went
judgment
to the
wasn't very good, right? The last
correct.
judgment, I felt
No,
like they came out and said, none of you were really harmed or something. Was that what the judgment
right,
was, where the court just said,
right,
well, maybe this happened to
right.
you, but you weren't harmed, so what?
Right. The decision of the Fifth Circuit was appealed to Supreme Court in the decision called Murphy v. Missouri. And it was not a
Right,
favorable
now.
decision. They said, oh, nobody here has standing. Nobody really has the right to sue. There was a fantastic dissent by Justice Alito saying that's ridiculous. They've clearly shown that the government put its fingers on the scales here and forced these companies to censor. So that case, though, was on an injunction. So that was a preliminary stage. That case has gone back to the district court in discovery. But our case, Kennedy v. Biden, sidesteps the problems that were identified in Murphy v. Missouri. There's no question that Kennedy and Children's Health Defense have standing. The White House specifically said, deplatform these speakers. And they didn't have that with the plaintiffs in Missouri v. Biden. So we're anxiously awaiting what's going to happen with the Fifth Circuit. I would love to come back and tell you about that when that happens. That decision should be
Yeah.
made soon as to whether there'll be an en banc hearing in the Fifth Circuit. And again, we would take that back to the Supreme Court. Kim, these issues matter to everybody. We have to have access to truthful information. And as we know, there was tremendous gaslighting with the government, in the fore during COVID about really life-changing, life-saving information. So we
Yeah.
can't. Children's Health Defense isn't a sort of a free speech organization, but during COVID, we directly were censored. And so many of our colleagues in the independent media space, we felt we had no choice but to step up and to bring these cases. And I'm very happy that they're still continuing. Our cases, it's a long road. And frankly, Kim, it's very expensive. But these are critical issues if we want to have a First Amendment that means anything.
So what would be the implication if you succeed in this case? What would change? What would the court be saying that would make an absolute change with how social media companies behave or how the government behaves?
Well, what we want is that the government cannot, behind closed doors, ever again negotiate with the social media platforms, the new public square, to have surreptitious agreements to censor people. If they're going to have any kind of restrictions around speech, and there should be some restrictions, Kim, I'm not saying that terrorist, organizations should have open season on social media, but they have to be out in the public square. We have to know what the government's policies are, and we have to know what the social media policies are. At the heart of what was so awful about what happened is it was surreptitious. You would post something and you would imagine that your followers saw it, and they didn't see it
Mhm.
because you were being sandbagged, you were being shadow
Yeah.
banned. The White House was communicating in secret. They were using this internet observatories at Stanford and these intermediaries to do what they are prohibited by our Constitution for doing. So we've got to have a new day when it comes to how these platforms are regulated and what the government can do with them.
So the idea would be that if your court case succeeds, that the courts would basically tell social media companies and the government, you can have these policies, but they have to be transparent. You have to have
Yeah,
some transparency
correct.
with the public.
Correct. And I think there need to be some of the same provisions that we have in broadcast media and in print media, which is that you can't, you have to be very explicit, and, viewpoint, anything with the government has to be viewpoint neutral, right? A
Mhm.
paper can say we want to have a conservative social media or a liberal. That's fine, but the government can't put its finger on the scale and say you have to censor this.
Thank you for watching this clip from the full Kim Iverson Show. If you want to watch the full show, visit KimIversonShow.com. The show airs every Monday through Friday at 5 p.m. Pacific, 8 p.m. Eastern. Again, it's KimIversonShow.com. See you there.